When you sign a contract, you might assume that verbal promises made during negotiations carry the same weight as the written terms. Unfortunately, that's not how contract law works. Understanding the four corners rule can save you from costly disputes and unenforceable agreements. The four corners rule, also known as the parole evidence rule, is a fundamental principle in contract law. It states that when two parties enter into a written agreement, courts will only look at what's written within the document itself to interpret the contract. Any oral promises, side conversations, or implied agreements that contradict the written terms cannot be used in court. The name comes from a simple concept: the four corners of a document. Everything that matters legally must appear within those four corners. If evidence exists outside the written contract and contradicts its terms, courts will generally refuse to consider it. This means several types of evidence become inadmissible in contract disputes. Conversations you had before signing the contract won't count. Written communications that weren't incorporated into the final document won't be considered. Even comments made by either party during a breach of contract case typically cannot override what the contract actually says. So why does this rule exist? The primary goal is to uphold the sanctity and reliability of written contracts. When parties take the time to put their agreement in writing, the law assumes that document represents their complete and final understanding. Courts view the four corners rule as essential for promoting certainty and predictability in business relationships. It encourages parties to draft clear and comprehensive contracts. It also minimizes disputes about what was or wasn't agreed to outside the written document. By focusing solely on the contract's language, courts avoid speculative or conflicting interpretations based on contradictory verbal statements. This principle places enormous importance on thorough contract drafting. You must include every promise and expectation in the original written agreement. If you rely on spoken guarantees made outside the contract, enforcing them later may prove impossible. Any judge reviewing your case will examine only what's written, not whatever verbal agreements you thought you had. Never trust someone who tells you not to worry about a particular clause because you have an understanding. While you might be in agreement at the moment, if the relationship deteriorates, you'll have no legal support for making that party honor your wishes. What seems like a friendly handshake agreement today can become a costly mistake tomorrow. However, the four corners rule isn't absolute. Courts recognize several well-established exceptions that allow external evidence under specific circumstances. Understanding these exceptions is crucial because they represent situations where you might be able to introduce evidence beyond the written contract. Fraud, duress, or undue influence represents one major exception. If you can prove the contract was entered under fraudulent circumstances or coercion, courts will allow external evidence. Similarly, if there was a mutual mistake or the contract involves illegal activity, evidence may be introduced to correct or invalidate the agreement. Ambiguity in language creates another important exception. When contract terms are vague or unclear, courts may look beyond the document to determine what the parties truly intended. This exception recognizes that even carefully drafted contracts sometimes contain language that can be interpreted multiple ways. Collateral agreements that don't conflict with the written contract might also be admissible. If you have separate agreements that are consistent with the main contract and independently supported by consideration, courts may recognize them. In commercial contracts, industry-specific terminology may require outside context to clarify meanings that aren't obvious to general audiences. Courts may also allow external evidence to correct transcription errors, prove that consideration was never offered, or demonstrate that one party committed unconscionable behavior. If the contract includes a clause stating that oral amendments are permissible, then verbal modifications might be enforceable. Evidence may also be used to clarify parties' identities in cases involving name changes. When contract disputes reach court, judges rely heavily on the four corners rule to keep proceedings straightforward. They use the written document to discover each party's original intention and decide based on that understanding, unless you qualify for one of the recognized exceptions. The court will only use external evidence to the extent necessary to clear up ambiguity or discover the original intent. Judges won't try to uncover hidden meanings or obscure definitions. Instead, They use the ordinary and straightforward meaning of words and clauses to determine how statements fit into the agreement as a whole. The typical procedure follows a clear pattern. First, the judge reads the written contract and decides whether extrinsic evidence is necessary. If the contract is clear and unambiguous, the court will enforce it as written without considering outside evidence. Only when ambiguity exists or an exception applies will the judge consider additional evidence alongside the contract's entirety to make a fair ruling. In the construction industry, the four corners rule plays an especially vital role. Construction contracts often contain detailed specifications, timelines, and payment schedules, making precise language absolutely critical. These projects involve multiple parties, complex coordination, and significant financial stakes. Relying on the written contract prevents parties from making claims based on informal emails, casual site conversations, or undocumented change orders. It encourages thorough documentation of all change requests, scope modifications, and timeline extensions through formal amendments or addendums. This helps courts adjudicate disputes without delving into conflicting recollections or verbal assurances that may differ dramatically between parties. Because construction projects are so complex, even minor discrepancies can lead to costly litigation. A contractor might claim the owner verbally approved additional work, while the owner insists no such approval was given. Without written documentation, the four corners rule typically favors whatever the contract states about change order procedures. It's important to understand that application of the four corners rule varies significantly depending on state jurisdiction. Some states enforce the rule strictly, refusing to admit any external evidence unless a clear exception applies. Other states adopt a more flexible approach, allowing extrinsic evidence even when the contract appears unambiguous. Texas courts, for example, tend to follow the strict four corners approach, giving great deference to the written contract. California courts, on the other hand, are more open to considering surrounding circumstances and parole evidence, even when interpreting seemingly clear terms. This variation means parties involved in contract disputes must understand how courts in their specific state interpret and apply the rule. This jurisdictional difference becomes especially important for multi-state contracts or disputes that could be litigated in different venues. A contract that seems airtight under one state's interpretation might be more vulnerable to external evidence in another jurisdiction. To protect yourself from complications stemming from the four corners rule, take proactive steps when drafting contracts. Define all key terms using clear and unambiguous language. Don't assume that common words have universally understood meanings, especially in technical or industry-specific contexts. Incorporate entire agreement clauses, sometimes called integration clauses. These provisions explicitly state that the written contract represents the full and final understanding between the parties, superseding all prior negotiations and agreements. This reinforces the four corners principle and makes it harder for either party to claim additional terms were agreed upon. Avoid any reliance on verbal agreements. If something matters to you, include it in the contract. Courts won't enforce promises that aren't written down, no matter how sincere they seemed at the time. This applies to everything from payment terms to performance standards to dispute resolution procedures. Ensure that any changes to the contract are documented through formal written amendments, not just casual conversations or email exchanges. Even if an email seems clear, it may not satisfy the requirements for modifying a written contract, especially if the original contract requires written amendments. Use consistent terminology throughout the document. If you call something a deposit in one section, don't refer to it as a down payment elsewhere. Inconsistent language creates ambiguity, which can lead to disputes and potentially allow external evidence to be introduced. Consulting legal counsel before signing important contracts is one of the smartest investments you can make. An experienced attorney can review the agreement to ensure it accurately reflects your understanding and protects your interests. They can identify potential ambiguities or missing terms that could cause problems later. The Four Corners Rule serves as a powerful reminder that in contract law, what you write is what you get. Verbal assurances, handshake deals, and informal understandings carry little weight when disputes arise. The written contract is your primary protection. your clearest evidence of what was agreed upon, and often your only enforceable recourse. By understanding this principle and its exceptions, you can approach contracts with appropriate caution and diligence. Take the time to read every clause carefully, ask questions about anything unclear, insist that all important terms be included in writing. Document any changes or clarifications through proper amendments. These simple steps can prevent misunderstandings and provide solid legal ground if disputes arise. Whether you're signing an employment agreement, entering a business partnership, hiring a contractor, or engaging in any significant transaction, remember that the four corners of that document define your rights and obligations. Make sure those four corners contain everything you need them to contain, because once you sign, that's likely all a court will consider.